Hi everybody, it's Charles from Novak Migration, also known as Karol. Karol is my Christian name, Charles to make it easier for locals. Migration agent, my MARA number, actually I can show you my MARA number and everything. Maybe not everything, but at least my MARA number. Okay, transition. Charles, Karol Novak from Novak Migration. Maybe let's hide that thingy. Okay, Charles, Karol Novak from Novak Migration. Thank you for being with me. Good afternoon, dzień dobry, zdравствуйте, guten Tag, whatever is your language. Today I'm going to share some information about the 482 visa. 482, also known as the TSS, Temporary Skills Shortage, I think is the full name of it, and the abbreviation for the abbreviation. Essentially, it's the temporary visa. It's the temporary employer sponsored visa, right? We've got a few people, 25. Let's wait for a bit longer before I will start talking about the visa. Actually, let's go ahead. 26 viewers. Thank you for joining. All right. So today about 482 visa. It's the work visa, employer-sponsored visa, so essentially you need an employer who would be willing to assist with the whole process, who would be willing to sponsor you for the visa. Unlike those skilled visas, the points-based skilled visas, you need an employer over here. And there is no invitation from Home Affairs. If you have got an employer who wants to sponsor you for the visa, happy days, we go ahead with the application. There are three stages for this visa. There is the sponsorship, nomination, and the visa application, list of occupations, labor market testing, and so on and so on. So I will touch the base about all of these things which are on your screens now. So let's start with the three stages. Sponsorship. This one is on the company. Company needs to get approval as the SBS or OBS, standard business sponsor or overseas business sponsor. Usually this Australian company who would like to become a sponsor and nominate people for various positions. However, the overseas company could become a sponsor for 482 as well. In the situations when the overseas company is investing into something in Australia, or they want to open their, open the branch in Australia, or if they got the contract with some Australian company and need to send their employees to fulfill the contractual obligations, that's when we can utilize 482. Yeah, you may argue that, yeah, but 400 is better. Yeah, 400, 3 months or 6 months. And if the job will take more than 6 months, then 482 is the one to go for. So essentially sponsorship, the first step, and its sponsorship is on the company. Company essentially must provide the evidence by proof, must prove that they are legally operating in Australia or overseas, making money, being able to pay salaries to their employees. And in Australia, it's usually identifiers, IBN, ABN, A Australian business number, ACN Australian company number, if this is the PTY limited. What else? Profit loss statement, lease with the for the place where they are operating. BAS from the ATO bank account statement. These sort of the documents are usually okay to get approved as a sponsor. How long company would have to operate to become a sponsor? The new companies may also become a sponsor, okay? And how much the company must, how much must be turnover to become a sponsor? There is no right or wrong answer, and with the companies, even with 50, 60, $100,000 turnover, potentially that company could become a sponsor. But hey, if your company has got $60,000 turnover, you're the owner of the company, and you want to sponsor somebody, how you can prove that you can pay them the salary? So 60,000 is for you. What about another 60,000 plus superannuation from a nominee, right? So how much? it would have to make sense in terms of the profit and loss statement that you can afford to pay nominee their salary. So there is no right, no wrong answer. How big companies, even if there are 3-4 employees, even if there is just one employee, that company can become a sponsor. It all depends, right? Fee for the sponsorship, 420, that's for Home Affairs. Keep in mind that the sponsorship now is being granted for 5 years, and within these 5 years, company can sponsor in theory as many people as they want. However, then dependent on how many Australians are working in the company, how big is the company, how many non-Australians are working, depends. So there is no simple answer how many people could be sponsored by the company. As long as it makes sense, as long as they are able to prove that they need people for the particular position and are not able to find anybody on the local market, can be fine. All right. So sponsorship on the company, Australian company or overseas company. The second step is the nomination. Nomination is for the position. All right, it's not for the visa applicant, it's for the position. Visa applicant is also being mentioned as part of the nomination application. Why? I don't know. They are asking for it, and you have to provide the details for the nominee. The visa applicant as part of the nomination is being called nominee. Nominator, that's the sponsorship. Sponsor, okay. For the sponsorship, there is a sponsor. For the nomination, the same company is being a nominator. Then the person who will be applying for the visa is nominee when we are talking about the nomination. All right. And as the nomination, as part of the nomination process, the company must prove that they need somebody for the particular position. There is something called genuine position requirement. Company will also have to prove that they are not able to find anybody on the local market in Australia. Now, there are no Australians, no permanent residents available for the role. So that's why companies need to do so-called labor market testing. Market salary rate, all right? So 53.9 thousand, it's an absolute minimum plus superannuation. That's the absolute minimum the company must pay for the to nominee, right? Less than that, nomination will be refused. However, there is also something called market salary rate, AMSR, average market salary rate. I think it's the abbreviation, and the company will have to prove that whatever is being proposed to the nominee is how much an equivalent Australian worker would get paid. So let's say you are running the IT company, and you are having the IT professionals, and you are paying them $120,000 per year, and then you want to sponsor somebody and you want to pay them absolute minimum 52.9 thousand. You might be facing refusal because you are simply abusing your nominee and you are underpaying them. You are going to underpay them. How you prove that the person is being paid the average salary rate for the particular position? You do the research, how much the other companies are offering for this position. If you have got another worker on exactly the same position, you will show how much the other worker is earning, and that usually should be fine to prove the equivalent Australian worker average market salary rate requirement. Otherwise, you do the research on the various platforms, how much the other ones are paying. You check what is the Fair Work instrument, relevant instrument award, Fair Work award, what relevant Fair Work award is saying for that particular occupation, what is the pay guide, and so on and so on. Caveats. Keep in mind that for some occupations, 53.9 it's not enough. For some occupation, minimum is 65,000. Right? TSMIT. Temporary skills migration income threshold. All right, TSMIT 53.9, but for some occupation it's 65,000. I think it's accountant, marketing specialist, and some other occupations. So if you want to pay them $60,000 and then you are doing, the nomination application and everything, and you think that's fine because the TSMIT is 53.9, you're facing refusal because there is the caveat which is saying 65,000 for that particular occupation. So keep that in mind. Fee for the nomination to Home Affairs is 330, but then there is something called SAF, Skilling Australians Fund. What is Skilling Australians Fund? There is the brilliant idea which Australian government is having that companies will be contributing towards skilling Australians. It's about people, not about Australia. Some people are calling it Skilling Australia Fund. No, it's not Australia. It's Australians Fund. So essentially, it is a levy which the potential work visa sponsor nominator is paying to Home Affairs. Then this money are going to Department of Education, and then the Department of Education is distributing the money to the schools, colleges, and universities. So the locals will be trained, so the employers will no longer have to rely on the overseas workers. So idea is brilliant. However, how it works, that could be a different story. How much is SAF? Dependent on the company's turnover for last financial year, it's 1,200 or 1,800 for year of the visa. So if the visa, for example, it's on the Emirati TSS, it could be granted for 4 years, and nominations for 4 years, you are looking at 7,200 for the Skilling Australians Fund, all right? And if that wouldn't be enough, then there is the card surcharge. If you would be using credit card, then there is another 1.4%, so 7,200, then another 100, just for paying with your card. So that's the nomination. The third step is the visa application. As part of the visa application, applicant must prove that they have got relevant attributes for the position. So in general, the person must have at least 2 years of work experience in the occupation or field related. That's what legislation is saying. 2 years of the work experience in the occupation or work related. Legislation does not say that it has to be on the skill level. Legislation does not say it must be full-time. Legislation does not say that you would have to have relevant qualifications. So in theory, if you would have 2 years of the work experience in the occupations or field related, in theory you may fulfill this requirement. But practically, the case officers are expecting that you would have 2 years full-time of work experience on the semi-skilled level. Okay, so after relevant qualifications, or if you would have just the work experience, especially for trades, that you would have at least these 2 years of the full-time work experience, which normally would be considered as the informal training. So instead of 2 years, you would be expecting to have 4 years of the work experience. So if you were on the student visa, part-time, 20 hours per week, even if you would have 4 years of the work experience, that would be sort of equivalent of 2 years. So it's sort of borderline. Sometimes doing the RPL or the skills assessment, it's helping. But then again, if you can do the skills assessment, if you would be a tradient, if you would be trying to do the skills assessment, you would need with RPL, you would need 5 or 6 years of the work experience. It's crazy. Yeah, we do a lot of 482s, and sometimes we are getting the grants for the borderline work experience. What's interesting, work experience is time of decision criteria for the 482, not time of application, time of decision. So in theory, if you would apply for the visa, if you wouldn't have 2 years of the work experience, and you would hope that it's gonna take weeks or months before the visa grant, and you will hope that this additional time will give you we will get you to 2 years, you may or may not be lucky. Recently, we are getting the decisions with 482s literally within days. And it is your obligation to provide the evidence that you satisfy at the time of sort of application. So 2 years of the work experience in the occupational field related, that's the most important sort of requirement for the 482 visa. Field related, that's quite interesting over here, and that's could be quite broad. Sometimes you have to argue with the case officer whether your work experience is related. Sometimes no-brainer. If you are applying for the visa as the chef, for example, cook, it's a different group, unskilled group. However, it's field related. So potentially you may take into consideration work experience as the cook if you're applying for a visa as the chef. But if you would have work experience only as the cook and without the tasks which are being for a chef, okay, bit of a stretch. You may not be lucky there. So work experience most important. Okay. Apart from that, you must prove that you are a person of a good character. What does it mean? You will have to provide the penal checks from each and every country where you have spent at least 12 months altogether, cumulatively, in last 10 years. No ifs, no buts, you have to. And I had situations where case officers didn't ask for it, but that was from the overseas business sponsor, and the applicant was already in Australia. Offshore, no ifs, no buts. Onshore, Australian sponsor, and essentially, yeah, you have to provide. And it's time of decision criteria, so you may potentially lodge the visa application without the penal checks in hand, but you will have to provide them by the time of decision. I know from some countries it's mission impossible to get the penal checks, but they will be asking for it. I had another webinar a week or 2 weeks ago about the character provisions and everything, so you may look at that one if character penal checks, this kind of stuff is maybe a problem for you. English requirement. All right, so for the 482 visa, again, depends if your occupation is on the MLTSSL or the ST-SOL. There are different English requirements. For the MLTSSL, you would have to have English vocational, I think. Vocational English. Yeah, all fives. In IELTS or all 36 in PTE at least. Okay, so 5 or above or 36 or above. That's if the occupation is on the MLTSSL. If the occupation is on the ST-SOL, it's overall 5, but no component less than 4.5. Why it's different for different occupations? No idea. The only exemption from the English is if the sponsor is the overseas business, OBS, and the proposed salary is at least $96,400, $96,400 plus superannuation. So that is the only exemption for English. No, actually not. That's the exemption, and then there are the other exemptions. If a person has studied in English, bachelor of whatever, 3 years study in English, that could be not studying English, but all of the subjects were delivered in English. So India, Philippines, South Africa, some other countries where Nigeria, you're speaking English, and if you would have been studying your bachelor, letter from the university that all of the subjects were in English is satisfactory. Some secondary application, high school or something like that, all the subjects delivered in English could be fine. And then another exemption is for the holders of the particular passports, UK, New Zealand, Ireland, Canada and US. It does not matter if you speak English at all. Dzień dobry. If you have got the UK passport, you don't have to sit an English test. So all of the guest arbiters in UK, US, who got passports, does not matter if you speak English, you have got the passport. So Home Affairs is assuming that your English is good enough. It's ridiculous but that's how it works. Canada, bonjour madame, Quebec. Parlez-vous français? Oui. Do you speak English? No. Have you got Canadian passport? Oui. Alright, your English is good. But it is as it is. So, exemptions. Passport, study in English, and for the overseas business sponsors, salary at least 96.4. Dependents. Dependents could be included in the application. Visa fees. Visa fee main applicant, this one is incorrect, it should be 2770, sorry for that. Okay, now it's correct. 695, 335. Yes, all right. So dependent whether the occupation is on the MLTSSL or the STSOL, the fees are different. Okay, Home Affairs, they are saying that the fees are for their time, for the processing the application. So I wonder what is the difference of their time when they are processing application with the occupation which is on the MLTSSL and the one which is on the STSO. The same visa, just two different applications, and the fees are totally different. 2,770 for the MLTSSL, 1,330 for the STSOL. Crazy. And then dependents, the same as the main applicant, the 18 years or over, so your partner of your child, 18 years or over, which can be considered dependent. I had another webinar which was about the dependents, so you can have a look on that one to know who can be a dependent, right, and included in the application. And then kids under 18 years, 695 for the MLTSSL and 335 for the STSOL. And then there is the subsequent temporary application charge 700 for each applicant. So if you are applying for the 482 visa and it is your second temporary visa application in Australia, there is the legislative instrument which is saying that if you have had this visa and you are applying for this visa, then the subsequent temporary application charge would apply. So if you would go from 485 to 482, I think the extra 700 no, but if you would be on the student visa, then applying for the student visa, then applying for the 482, yep, 700 per head. Why? Just because, why not? If you would be on 482 and then applying for another 482, and if you would have had, if you would have applied for some other temporary visa in Australia, then this extra 700 would apply. So 2.7 thousand for the primary, 2.7 for the secondary, 700 for two kids, and then 4 times 700 for the subsequent temporary application charge. And let's say your employer would decide that they are paying for the SAF only for 1 year, not for 4 years, because they want to save money. So they are paying for the SAF just for 1 year. You are applying for the visa for 1 year. If the employer would decide that they are paying SAF for 4 years, you will get the visa for 4 years. Crazy. Yeah, but you know what? I will show you the Excel spreadsheet which I'm using with all of the fees. How does it cost to get the 482 visa? Sometimes it's costly. All right. So the visa application, list of occupations. ANSCO, Australian New Zealand Standard Classification of Occupations, Australia, ANSCO, ANZSCO. That's where it comes from. Australian Bureau of Statistics, come on. Alright, so Australian Bureau of Statistics some time ago got an idea that they will put all of the known occupations in Australia into some groups, subgroups, major groups, minor groups, unit groups, and so on and so on. So whenever you're applying for any visa, you need to specify the occupation from the ANSCO. There is a bit over 1,000 different occupations in the ANSCO, and then when you're applying for the visa, you have to specify the occupation, all right? And then, depending on the occupation, you may or may not be eligible for the particular visa. So then we have got the list of occupations. Migration, Lean 19/04048, specification of occupation, subclass 482 visa, instrument 2019, latest version in force, legislation gov.gov.au. That's where you are looking for the most recent list of occupations. Not Facebook groups, not YouTube, not what your friends have said, not the Home Affairs. That's the source. Of course, people are looking at Home Affairs or some other stuff. I do that sometimes as well, but before I launch the application, usually I'm checking, over here. What's the story? And then we have got the MLTSSL, STSOL, short-term skilled occupation list, and then the ANSCO codes, and then the caveats, if the caveats apply. And on the STSOL, there are 215 different occupations. Then there is MLTSSL, also with some caveats. where there is how many? 216 occupations. Footballer, so NRL, soccer. What is the soccer? It's a football. I don't know why they call it soccer here. 25, that's the caveat. I think they will have to get paid 120,000 or something like that to be sponsored as the footballer in Australia. And then there is role. Role is for the regional Australia. And makes sense. Farmers, growers. So Brisbane, Sydney, Melbourne, you cannot sponsor any of those people for the 482 in general. And there is 77 of these occupations. And here are the caveats. 25, what was the footballer? 25. 25, the position, 120. So if there is any club which would like to sponsor footballer for the AFL, NRL, the soccer, $120,000 plus per annum age, that's the salary. They would like to pay less than that, not possible. 65,000, that's the most common. Yep, the position has nominated of less than 65,000, right? So that's caveat number 2. Where are number 2s? Let's find something. 2. Technical sales representatives not elsewhere classified, caveat number 2, and then 15. So if there is the occupation with the caveats, you have to have a look what the caveats are about. Marketing specialist, 2, 11, 19. What is 2? 2 is, 65, 11. The position is based in a frontline retail setting or predominating involves the client transactions on a regular basis. So there are some companies which are trying to sponsor salespeople as the marketing specialists. So there is the caveat. And what was the other one? 19. It's in a business that has an outcome of less than $100 million. So to be sponsored as the marketing specialist, the business must have a turnover for at least $1 million. And they are looking at the turnover for last financial year. So, a company might become the sponsor. Company might then apply for the nomination, and as part of the nomination, they are caveats are sort of for the visa. But these must be satisfied at the nomination stage. So if we have got the marketing specialist companies trying to sponsor marketing specialists for 482, and if they have got the turnover of less than $1 million, what's the point of going through the whole process? You might have all of the skills, experience, and whatever. The company could be doing with the advertisements. It could be advertisement company, but if they have got the turnover less than $1 million, end of story. The accountants, if the company must have at least 5 employees. If there is less than 5 employees, there's another caveat. So keep in mind the caveats. So occupations for the 482. I'm getting this question a lot. Is skills assessment required for 482? For some occupations and people from the particular countries, yes. Mostly it's about trades, okay? There is also program or project administrator, and there is specialist managers not elsewhere classified. So these would be vet assess, and all of the trades would be through the TRA. And from the particular countries. So if we would have a chef, for example, from Bangladesh, Brazil, China, Fiji, blah blah, and Samoa, and so on, from any of these countries, to be eligible for the 482, they must do the skills assessment. Okay, unless they would have studied in Australia. There is the exemption. Exempt applicant if person holds a subclass, person satisfied, person is employed in Australia, holds relevant qualification. There we are. Successful completion, blah blah blah. So if the person would have studied in Australia 2 years full time, they might be exempt from the skills assessment, right? But studying in Australia and then 2 years of the work experience required, you might have had these 2 years of the work experience before finishing the study in Australia. So you remember, they don't say that the work experience must be on the skilled level, and you might have these 2 years of the work experience during the study as well, but usually it would be the part-time. But that would make you exempt from the skills assessment. Very likely. So skills assessment for some occupations from some countries would be required unless the person would be exempt person and would fall into any of these exemptions. Labor market testing. All right, so legislation. There is another legislation for the labor market testing which must be satisfied. Okay. Just make sure that you are looking in the latest version first, because the legislation is changing from time to time. And in general, the advertisement must be placed. It's a formal recruitment process. The employer must go to the recruitment process to prove that there are no locals available for the role. They need to advertise for the 4 weeks, 28 days, and the advertisement must run, the whole 28 days must be within 4 months before the nomination application, all right? So the advertisement must have started within 4 months before the nomination application. And there are very, 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 very specific requirements for the advertisement. If these requirements are not met, end of story. The LMT not met is the most common reason for the refusals from what I have seen from the self-lodged applications. And if you want to know what are the requirements, go over there. It does not have to be employer who is doing the LMT. They can use some recruitment company who do the advertisements for them. All right. It's not only about placing the ads. It's the formal recruitment process. So the employer must make an effort trying to get somebody from the local market, okay, and trying to find whether there is somebody available for the position. It's a tricky situation. Quite often, there is an employer willing to sponsor somebody and they want to sponsor that person, and that person might already be working for that company on some other visa, 485 student, 408, whichever, and that company wants to sponsor. So why do I have to do the recruitment thingy if they are already with me and I'm happy with them? That's the legislative requirement. And if the person is already working over there, they can say that the genuine position, that the doesn't matter. All right, so LMT it's required. Legislative requirements must be done in the particular manner. The advertisement must be made on the Workforce Australia. That's the government website, and 2 other ones. You can do Seek, Career One, Jora, Indeed, potentially, but I would be careful with that. LinkedIn, Gumtree, no. Facebook, no. Any of those social media, no. There are specific requirements. Read the legislative instrument to make sure that you are doing, not you. You cannot do it. It must be your employer. If you do it on behalf of your employer, that could also be the reason for the refusal. All right, so that's the LMT. Then genuine position. That's another thing where the employer must prove that the position is genuine. Restaurant sponsoring chef, no-brainer. Restaurant sponsoring the restaurant manager, no-brainer. Restaurant sponsoring the plumber, huh? Okay, how they can prove that they need the plumber? And for 482, position must be full-time in the particular occupation. It cannot be jack of all of the trades. Must be in the particular occupation from ASCO. I know sometimes it's almost impossible, but that's how legislation works. Person must have the job offer for the particular position, must be full-time, not part-time, full-time, okay? There are some exemptions, but in general must be full-time. So genuine position, a company must prove that they need somebody for the particular position, and they must prove that the position has not been created for the migration outcome for the nominee, right? So whether there is the increase, actually we will open this genuine guide thingy. I have got the document which I'm sharing with my clients and telling them what to do in particular situations. Regulation 519.5K requires that nominating business demonstrate that they have genuine need to employ the nominee in their business. All right. The vacancy exists for the nomination position. So when making the assessments, case officer will consider whatever is in the application, but that's not all. You will have to provide some sort of the evidence. Increasing the business activity, plans for the expansion. This is interesting. What would be the impact if the nomination would be refused? Overtime being undertaken by the employees currently working for the company, showing that, okay, you don't really want them to do the overtime, you need somebody else. Relevant industry in decline, so that's when they can do their own, case officers can do their own research. The position continues to fit within the regular ongoing business activity, has altered over time, involves new tasks that no longer equal to nominal occupation. So in general, it's about showing that the business needs somebody for the particular occupation. Sometimes it's easy as, and it's no-brainer, but sometimes there is a bit of explaining why this particular occupation, why this position, why company needs somebody like that, and then it's about the submission letters, it's about the additional evidence, and so on and so on and so on. We do it for the businesses quite often as well. So genuine position. And I've also seen self-lodged applications where the refusal was saying that, in our opinion, position has been created for the migration outcome. What does it mean? Okay, and later I will explain the pathways to permanent residency. So they are saying that the position, that the nomination is refused because there is the migration outcome, but then there is the pathway to the permanent residency. Welcome to the student visa world. Who can be included in the application? Primary applicant, and primary applicant will have to satisfy the requirements for the occupation. Okay, requirements for the occupation, work experience, English, and character. Dependents, partner and children could be included, and partner must provide evidence that they are a partner. Children must provide evidence, or the applicant would have to provide the evidence that children are their dependents. Okay, each and every person who is 16 years or over will also have to satisfy the character assessment. So dependents 16 years or over, whether partner or kids, will have to provide the penal checks. From each and every country, they have spent at least 10 years cumulatively in last 10 years, but after 16 years old. So if they would be 18, they will have to provide the penal checks from last 2 years, countries where they have lived for last 2 years. Okay. Visa conditions. Work limitation for mine applicant. They can work only for their employer and only on the particular position. In some circumstances, they may work for the associated entities, but that's the different story. I don't want to delve into that over here. Health insurance. Years ago, you had to provide the evidence that the health insurance is organized before the visa application, but now there is the condition that the whole family, every visa holder must have a health insurance. And the health insurance, the best is to have OVHC. There is quite a few medical insurance providers in Australia, overseas visitors health cover. But in theory, you might have some overseas health cover which may, satisfy the requirements for the OVHC. I wouldn't really go and get the overseas one. Go get the Australian one. It's the visa condition that you must have the visa. You must have the health insurance. It could be quite costly for the family of few, but you don't pay, unlike for the OSHC, for the student visa, you don't pay for the whole 2, 3, 4 years up front. You can pay weekly, monthly, fortnightly, whatever. The thing is that Home Affairs, they will not be checking whether you have got the OVHC or maybe let's say differently. It is very unlikely that the case officers will be asking you if you have got the OVHC, but once you will be applying for another visa in Australia, or if permanent residency is your goal, usually there is the requirement that the person must have complied with the visa conditions. Must have complied with their previous visa conditions to be eligible for another visa. So let's say you're on the 482, you're applying for the ENS, and then there is the requirement that you must have complied with the previous visa conditions, and then they are asking you, all right, so provide the evidence that for the whole duration of your 482 you have had the health insurance, and then you will say, I haven't had one for the first year of my 482. Then they can say, all right, it's not a problem. Your ENS is being refused based on the fact that you didn't comply with the previous visa conditions. So be careful. If you want to save a couple of dollars and not get the OVHC, you're in the breach of the visa condition, that's one thing. And then if something will go wrong and you don't have the health insurance, it might get costly. So main applicant, the work condition is that the main applicant can work only for the employer, only on the nominated position. Dependents, full-time work rights, dependents, full-time work rights in general, and they can work for whoever they want. It's not a visa condition, but kids from 5 to, I don't remember what is the highest, would have to go to school. Okay, there is the requirement in Australia that kids of a certain age must go to the school. Not a visa condition, but a legislative condition in the Education Act or some other act. And the thing is that it all depends on the state, and it all depends on the educational agency, department of the particular state. Whether they would require the kids, the schooling for the kid to be covered by the parents or whoever or not. Some states don't require payments for the school for the kids on 482 visa, some do. Some states, dependent on the occupation, you might or might not need to pay. Some states might have some sort of the exemptions. You will have to follow up with the state, with the particular state, to find out whether you would have to pay for the schooling for your kids or not. All right, pathways to PR. All right, so 482, here we are. Nomination refused based on the fact that, in their opinion, the position has been created for the migration outcome. And then there is the provision to permanent residency. So if your occupation is on the MLTSSL, no brainer. Visa granted for 4 years, and after 3 years, you can apply for the ENS through the transition stream. Permanent residency, also sponsored by the employer, and skills assessment is not required. If you want to do it under the direct entry stream, and yeah, you can do that, but then you will have to have 3 years of the skilled work experience and the skills assessment, and your employer must be willing to sponsor you for the ENS. So transition stream, after 3 years on the 482 for occupations on the MLTSSL, ENS direct entry, overall 3 years of the work experience, if employer is willing to go ahead. If your occupation is on the ST-SOL, different story. There is no pathway to permanent residency as for the occupations on the MLTSSL, all right? So normally visa granted for up to 2 years and could be extended for another 2 years in Australia, but normally there is no pathway through the transition stream to the ENS. Unless you might have worked on 482 over COVID, 2019, 2020, 19, 20, 21. Yes, there is an instrument which is saying that if you have worked in Australia over COVID, you might be eligible for the ENS through the transition stream, 482, 3 years, transition stream. But that's only for those people who have worked over COVID in Australia. They might become eligible for the 482, ENS through the transition stream, even if their occupation is on the ST-SOL. The other pathways, skilled migration, 199, 190, 491. GTI, Global Talent Independent, if you are smartest, brightest, and potentially you might get invited for the GTI 858. Partner visa, if you have got an Australian partner, husband, wife, de facto partner, partner visa could be an option. Sometimes people don't realize that, but there are two of you. You are the main applicant for 482, and then your dependent who is having the full-time work rights. It's working for somebody else, but they have got, all the skills, work experience, skills assessment, and that employer is willing to help you getting the permanent residency. Then you can apply for the ENS direct entry. Your partner could apply for the ENS direct entry, and then you, mine applicant or primary visa holder for 482, will become a dependent on the ENS application for your dependent. So dependent is becoming main applicant for the ENS application. Doable. So there are some pathways to the permanent residency, dependent on the occupation, dependent on your status, whether married, single,